Today, BRR speaks with Richard Winter. He's a partner in the Banking and Financial Services Group at Middletons in Sydney. Welcome to BRR, Richard.
Thanks, David. Happy to be here.
Richard, last week we saw the changes to the Personal Properties Securities Bill pass in the House of Reps, allowing for a more flexible start date for that new regime to kick in. Are there any indications yet on when the start date will be?
Oh, look, David, there's no indication as yet as to the actual start date. The Attorney General's Department, they've been giving repeated representations that it will be early in the new year. But we do anticipate, given these amendments that are coming in, that they've done it to extend it beyond the 1 February date in 2012.
So when it does go live, what will happen when it kicks off?
Well, look, there's going to be a fundamental change the way the law works in respect to security interests in personal property, and that's for the entire country. At the moment, there's 40-odd jurisdiction-specific registers. They're all going to get closed down and they're going to get collapsed into one single national on-time register, and that's going to be a real-time register. So it's a big change. And the other most really important aspect of this change is that there's going to be a coverage of all personal property, and that includes everything other than interest in land, and also certain interests that have been specified by the states. Probably the most important one of those is in respect of resource licenses and tenements. The other really big impact of this Act will be the fact that it's going to be covering things that have not previously been considered security. These deemed security interests include things such as PPSA leases and retention of title rights. In the past, they've never been subject to registration because they've been seen to be the goods of the party supplying them. They are entitled to them. The Act changes all of that.
Right. Well, it does seem to be such a broad-reaching reform, and no doubt the big financial institutions will have been preparing for this for a long time now. But, are there any sectors or businesses that are sort of flying under the radar and will be significantly affected by this?
The two key examples I can think of where there will be a profound effect that hasn't been an issue in the past is both in respect of suppliers who've in the past relied on the retention of title rights they've had, and also equipment lessors who own the goods and lease those goods out. And the comfort that both of those type of parties have had in the past is that if their customers gone under, they'll be able to retrieve those goods because they own them. The Act changes all that, as I mentioned before, and because of that, we're looking at a fundamental departure from what the common law position is. These deemed security interests mean that a failure of those sort of parties to register their interest in this new register could mean that they either, one, lose their priority position if they haven't registered within a certain time, or more fundamentally might even lose their goods completely. And that could result in them being an unsecured creditor with respect to their counterparty. Just to put a bit more flavour to that as well, customers under this new Act, they might even be able to, and quite often probably will, be able to use the goods that are subject to that supply or that lease and offer them up to for instance, their transactional bank as part of their general security interest. So you can have a situation where a customer is actually given, effectively, pledged security over goods which are owned by a third-party supplier. So these are changes which are so important to these industries that if they don't get an understanding of it now, they could potentially be in a position which we saw happen in New Zealand, where certain companies, after that Act got introduced, they lost their goods in the insolvency of their customer and wondered why that occurred, because they didn't actually grasp this really profound part of the Act. The interesting thing about this is it becomes, in the past it hasn't been an issue because you've had companies saying, well, here's my charge, I'll register, and the decisions that have been made have been pretty simple because there have been large assets to register. For some of these customers, and I know some of our clients, they have hundreds of thousands of customers.
Absolutely.
They've got a huge burden in terms of determining on a commercial basis whether or not they're going to now go off and register their interests. And there may be situations when they decide that even though they could register, the feasibility of it and the time it would take to do it just doesn't work from a commercial perspective. So this new Act brings into play a lot of difficulties for clients because they no longer just look at the legal implications of the Act. They've got to really consider what the commercial impact of this Act will have on their business as well. I think it's also very important to note with this new Act that it doesn't just affect the financier or supplier side of a transaction. The implications for borrowers and purchasers are also quite important. The way the Act works, because it basically assumes or brings into being certain security interests, there are borrowers out there that are, and quite a lot of them out there, that will be subject to negative pledge restrictions. So that will stop them. It actually gives an undertaking, the borrower gives an undertaking not to put in place new security interests. When this triggers, they will automatically have provided a security interest that they weren't allowed to do. So one of the things we recommend to our clients who are corporate clients or other clients that are borrowers or purchasers is to open up a dialogue with their financiers and their suppliers, for instance, where they either do not want to have interest registered against them or they're concerned and they want to avoid triggering a default by breaching a negative pledge covenant.
And just finally, when we do find out the start date, I guess towards the start of next year, does it all come into effect straight away, or is there some sort of period to get used to all this?
The actual date that they will announce will be the actual go-live date. So that is the date that it will start. There's basically a month before that date they will have to give a month's notice, because what will happen is that'll be the time period for the migration of all the data on the different registers. So at the very least, you'll know a month before what that date's going to be. But having said that, there's some complex provisions within the Act that allow for a 24-month transitional period where security interest that previously couldn't be registered, so right now if there's a security interest which is not registrable, you'll have 24 months to perfect that security interest and maintain your priority position. But when it comes to new security interest after the go-live date, it needs to be registered straight away. That's the date.
So we'll certainly keep an eye on for that drop-dead date and leave it there for now. Thanks again for your time today, Richard.
No, not at all, David. Pleasure.
That was Richard Winter, a partner in the Banking and Financial Services Group at Middletons in Sydney. Listeners, if you have any questions for Richard about this interview or the regime, please send a message using the panel on your screen, or otherwise email through to BRR@bRR.com.au.